Very good morning to you all, dear students. In today's class, we'll start from second question of third unit, that is write an essay on reference, review and revision. So let us start from the answer. The answer shall contain about the reference, review and revision following important points. And what are the following important points? Reference is given under section 113 and relevant order is order 46. Section 113 of Civil Procedure Code talks about the reference, the object of reference, what is the object of reference, and what are the conditions for making a reference. Next point is following conditions are required to be fulfilled, that who may apply, power and duty of High Court, limitation period for the reference, and the meaning of review, what is the meaning of review, what is the object of review, who may apply for review, for the relief of review, and when review lies, when a review can be made. Parties, who are the parties for making review, what are the grounds for making review, and discovery of new evidence is available, then what happened, error apparent on the face of record, and other sufficient reasons and grounds. And next is difference between first appeal and revision, difference between revision and review, difference between reference and revision, difference between reference and review, and difference between reference and appeal. So let us start from reference, which is given under section 113 of the code, and the relevant order is order number 46 of the code. Okay, so what is section 113 provides about the reference of the CPC? It empowers a subordinate court to state a case and refer the same for the opinion of the court, and such an opinion can be sought when the court itself feels some doubt about the question of law. So 113 empowers subordinate court to state a case and refer the same for the opinion of the High Court if the subordinate court itself feels some doubt about a question of law is involved in that case, and such opinion can be sought when the court itself refers the case to the High Court. The High Court may make such order thereon as it thinks fit on receiving of application of review, petition of review by a subordinate court, and such opinion can be sought by a court when the court trying a suit, appeal or execution proceeding entertains reasonable doubt about a question of law. The object of reference, what is the object of reference? Object of the provision for reference is to enable subordinate court to obtain in non-appealable cases the opinion of High Court in the absence of question of law, and thereby avoid the commission of an error which would not be remedied later on, and it was held in the case of Chotu Bhai versus by Bakshi AIR 1941. So in this case, the court held that the object for the provision of reference is to enable subordinate court to obtain in non-appealable cases the opinion of High Court in the absence of question of law, and thereby avoid the in the presence of a question of law it is, and thereby the commission of an error which could not be remedied later on. Okay, so it is the object of reference. Basically, what are the conditions for the reference? The conditions are provided and prescribed by order 46 rule 1, and the High Court cannot entertain a reference from subordinate court until the conditions prescribed under section 40 order 46 rule 1 is made. Okay, following conditions are required to be fulfilled for making a reference under Order 46 Rule 1. What are the conditions? Number 1, there must be a pending suit or appeal in which the decree is not subject to appeal or pending proceeding in execution of a decree. A question of law or usage having the force of law must arise in the course of such suit, appeal, or proceeding. The question of law or usage having force of law must arise in the course of such suit or appeal or proceeding. Number 3, the question must relate to the validity of any act, ordinance, or regulation. Number 4 is the subordinate court is of the view that the impugned act, ordinance, or regulation is ultra vires or any provision thereof is inoperative in nature. So there are 4 conditions which are required to be fulfilled under Order 46 Rule 1 of Civil Procedure Code for the purpose of making of reference. First condition is there must be a pending suit or appeal in which the decree is not subject to appeal or pending proceeding is execution of such decree. Second is the question of law usage having the force of law must arise in the course of such suit or appeal or proceeding. Third is the question must relate to the validity of any act, ordinance, or regulation. And the fourth is subordinate court is of view that the impugned act, ordinance, regulation is ultra vires or any provision thereof is operative in nature. So these are the required conditions must be fulfilled for the purpose of making a reference. Who may apply for reference? Only a court can refer either on an application of party or suo motu. So the reference can be made by the court itself either on the application received by the parties to the suit or on its own motion. A reference can be made by the High Court. A court, subordinate court to the High Court. What is the power and duty of High Court? The jurisdiction of the High Court is consultative in nature and the High Court may answer the question referred to it and send it back the case to the referring court for disposal in accordance with the law. And the High Court may also refuse to answer the reference or even to quash it. It's on the discretion of the High Court that either it entertains the question or it refuses to answer or they answer the reference or even to quash it. All these powers are given to the High Court on receiving a reference. Okay, the High Court however cannot make any order on merits, nor can it make suggestions. However, High Court cannot make any order on merits, nor can it make any suggestions in reference to the case made for the in context of reference. Okay, limitation period is what? No limitation period for the reference is provided as soon as the question arises, and the court can refer it to the High Court at any time. Okay students, so it's all about the reference and just wait for a second. Okay, fine. Next we have to deal with revision. Review. It's review. The concept of review is given under section 114 and order 47 of the code. The provision relating to review constitutes an exception to the general rule that once the judgment is signed and pronounced by the court, it becomes factus officio, that is, ceases to have control over the matter and has no jurisdiction to alter it as provided under Order 20 Rule 1 of the Code. So, the provisions relating to review constitute an exception to the general rule that once a judgment is signed and pronounced by the court as given under Order 20, Rule 1, it becomes absolutely factus officio. That means the court ceases to have control over the matter to alter, to change, or so on. Okay. So once a judgment is signed and pronounced by the court cannot alter or change any kind in the judgment, because the principle of factus officio, that means ceases to have control over the matter, as provided under Order 20, Rule 1 of the Civil Procedure Code. What is the meaning of review? The meaning of review is to reconsider or look again, to re-examine the case. Okay? To look again or re-examine the case. In legal parlance, it is a judicial re-examination of the case by the same court and by the same judge. So, what is the meaning of review? Review, as we can understand by its name, review means to reconsider. Review means to reconsider or to look again or re-examine a case by the court which has passed it, and in legal parlance it is a judicial examination of the case by the same court and by the same judge. And in review, a judge who has disposed of the matter reviewed on earlier order passed by him in certain circumstances. So, review can be made by the same court and by the same judge, and in review, a judge who has disposed of the matter reviewed on earlier order passed by him in some certain circumstances. Okay, students, so it was the meaning of review. What is the object of review? The remedy has been borrowed from the court of equity, and the basic philosophy inherent in the recognition of the doctrine of review is acceptance of human fallibility. Okay, so review is basically based on the decisions, uh, rules rules made by the court of equity, and this remedy has been borrowed from the courts of equity, and the basic philosophy inherent in the recognition of this doctrine of review is acceptance of human fallibility. And if there is an error due to human failing, it cannot be permitted to perpetuate and to defeat justice, and such mistakes or errors must be corrected to prevent miscarriage of justice. The justice is above all. Law has to bend before justice. Okay, so it was the object of review, and as we all know, it is borrowed from the codes of equity, and basic philosophy of recognition of this doctrine is the acceptance of human fallibility, and not to perpetuate or to permit or to defeat justice of human fallibility, and such mistakes or errors must be corrected and to prevented from miscarriage of justice, and the justice is above all, and the law has to bend before justice as well. So dear students, I hope you all are understanding my lecture. Thank you for watching my video. In my next video, we will discuss rest of the topics related to review. Thank you.